All right, welcome. If you're an aspiring barrister, this is for you. We're not just going to go over the rules of evidence today. We're going to build your toolkit, the one you'll actually use to win cases in court. So, let's start with the most fundamental question you will ever face. Your entire case hinges on proving a single fact. How are you going to do it? Because that's the job, right? Turning a story into something a court accepts as true. So here's our plan of attack. We'll start with the absolute basics, your core evidentiary tools. Then we're going to dive into a really tricky area, written agreements. After that, we'll look at the nuances of reading people and places, and I'll show you some clever shortcuts, evidence without proof. And we'll finish with the final critical check you have to make for every witness. Okay, let's open the toolkit. You know, no matter how complex a case gets, pretty much everything you build in court will rest on three fundamental pillars of proof. Let's get into what they are. Here they are: testimony, documents, and real evidence. It looks simple, right? But mastering the interplay between these three is everything. Think of it this way. Testimony is what people say. Documents are what's been recorded. And real evidence is the actual stuff involved. So first up is testimony. This is the human element, you know? It's someone getting in the box, taking an oath, and telling their side of the story. It's the absolute heart of most trials. Next, we've got documents. And you have to think really broadly here. This isn't just a signed contract on a piece of paper. We're talking emails, text messages, computer backups, CCTV footage. If information is recorded on it, it's a document. And finally, there's real evidence. This is the tangible stuff, the things you can literally pick up and show the judge. It could be the alleged weapon in a criminal trial or the faulty product in a civil one. It's evidence that often speaks for itself. Okay, now let's see how these tools work together, especially when you've got a written agreement in front of you. This brings us to a rule that, lets me tell you, trips up so many people in their bar exams. It's called the Parol Evidence Rule. So what is it? Well, in a nutshell, if you have a contract that looks like it's the whole deal, this rule stops anyone from coming in later and saying, "Oh, but we had a conversation beforehand that changed everything." The rule basically says the final written document is king. And you're going to see clauses just like this one all the time. It's called an entire agreement clause. When you see this in a contract, a big flashing light should go off in your head, and it should be screaming, "Parol Evidence Rule, Parol Evidence Rule." But, and this is a huge but, here's the twist every good barrister knows. The exceptions are where the fight is. The rule exists to protect a valid contract, not to hide a fraudulent one. So, if you have evidence that the contract was based on fraud, or a mistake, or was a total sham from the start, then the rule doesn't apply. The door swings right open. All right, so we've talked about documents, but what about the people? Let's circle back to real evidence, but this time, let's look beyond just physical objects. We're talking about something way more subjective. The people standing right there in the courtroom. Yeah, this is where it gets really interesting. A witness's nervous tap, the way someone limps to show an injury. These aren't objects you can tag as Exhibit A, but they are absolutely a form of real evidence. Why? Because the judge is observing them directly. The real question is, how much weight do you give this stuff? And that leads us to this incredibly important quote from the High Court. What it's saying is, a judge's vibe check of a witness isn't the be-all and end-all. If a witness seems shifty, but the documents, the hard facts, back up their story, the documents win. An appellate court can and will overturn a decision based on a gut feeling that flies in the face of cold, hard proof. Now, here's a classic exam distinction you've got to know cold. A demonstration versus a view. A demonstration, where a witness reconstructs something in court, is evidence. But a view, where the court goes to visit a location, is not evidence. It's just an aid, a way to help understand the testimony. Big difference. Okay, ready for the advanced moves? Let's talk about how you can prove a fact without calling a single witness or handing up a single document. These are the barrister's shortcuts. So, there are three main ways you can get a fact accepted by the court without formal proof. These aren't really steps in a sequence. They're three different tools in your kit. Learning how to use them effectively will make you a much more efficient and dangerous advocate. First up is the formal admission. The easiest way to think about this is that it takes an issue completely off the table. If the other side admits a fact in their pleadings, that's it. It's proven. You can't lead evidence on it. They can't lead evidence on it. The argument is over. Next is judicial notice.
These are the facts that are so well known, so obvious, that it would be an absolute waste of the court's time to try and prove them. A judge doesn't need an expert witness to know that cancer is a serious illness or that kids get into trouble. It's just common knowledge.
And the third shortcut is using a presumption. Now, these are really powerful because they actually shift the burden of proof. The classic example, if you can prove a letter was properly addressed and stamped, the court must presume it was delivered. It's then up to the other side to prove that it wasn't.
Okay, so you've got your testimony lined up. But before you even think about calling that witness, you have to run them through 2 final gatekeeping tests. Trust me, you do not want to stumble here. Here they are, competence and compellability. It's a 2-part question for every single witness. First, competence. Can this person legally give evidence? Second, compellability. If they can, do they have to? Now, most witnesses are both competent and compellable, but this is where you find tricky exceptions for people like spouses or co-accused. You have to check. So what's the big takeaway here? It's that the law of evidence isn't just a list of rules you have to memorize for the bar exam. It is a practical, dynamic toolkit. Knowing which tool to pull out, when to rely on a witness, when to let a document do the talking, or when to use a smart shortcut, that is the difference between knowing the law and actually being able to build a winning case. We've gone through the what and the how. We've laid out all the tools on the bench. But the real art of advocacy, the real challenge in front of you, is learning how to pick them up and construct a persuasive, winning argument. That's the job.